Welcome back. We continue with section 11 of Transfer of Property Act. Section 11 speaks about restriction repugnant to interest created. Restriction repugnant to interest created. See, if you know section 10, section 11 is automatically you can assume because it has the same logic. Where there is an interest which is created, an interest is created. Okay, an interest is created, but there is a restriction also saying that you cannot enjoy this interest in so and so situation, so and so situation, so and so situation. There is an interest. This I am transferring this property to you, and then I say I am transferring this property to you, but you cannot do this, you cannot do this, you cannot do this, right? So there is a restriction which is repugnant. Repugnant means what? Which is opposite, which takes away what? The interest which is created. I am creating an interest for the person in a property, but at the same time I am saying even though I am creating an interest in the property for you, you should not do this, do this, do this, do this, do this, do this. Understand? So what happens? The restriction is repugnant. If there is a restriction, see, if I am saying I am transferring this property to you, but you shall not sell it to anybody else till your death, after which it shall pass on to your son or daughter or whatever it is. This is a valid right. This is not a restriction which is repugnant to the interest created. Say for example, ancestral properties. Okay, if I say I am giving this share to you, if you maintain this share well, I will give you one more share. All these will not work out because it is a restriction which is repugnant to the interest which is created. Always when we say an interest, it should be an absolute interest. Am I right? See, even if we are talking about lease rental agreement, the interest created in the property due to the lease or the rental or whatever it is shall be absolute. What is the interest which is created during lease? He shall be in absolute possession of the property. Okay, you shall be in absolute possession of the property, but if you are not in absolute possession of property, I will not do this for you. That cannot be done, right? So if he is in absolute possession, he will be the one who has to take care of the whole this. So any restriction which is, you can be in possession, but you can be in possession only up to 10 p.m. in the night or between 10 p.m. and 6 a.m. in the morning. You can be in possession of the rental property only between 10 p.m. and 6 a.m. What is the purpose of the lease agreement? Practically itself it happens like that. We have, I have no this thing about that. But still when we are writing a lease agreement, we cannot write such right? Because it is repugnant to the interest which is created. So any restriction which is put with repugnant, which is repugnant to the interest created, shall be void. Such restrictions shall not operate at all. Understand? We move on to the next section, section 12. Section 12, condition making interest determinable on insolvency or attempted alienation. What does it say? Where property is transferred subject to a condition or limitation, making any interest therein reserved or given to or for the benefit of any person to cease on his becoming insolvent or endeavoring to transfer or dispose of the same. Such condition or limitation is void. Again, see section 10, section 11, section 12 all have the same logic. Any condition which is imposed, which is repugnant to the interest or the right or the title created shall be deemed to be void. Simple. So what is the situation in section 12? Section 12 says any condition, any limitation, any condition which says your interest in the property shall cease if you become an insolvent, okay, or if you try to dispose of. Cannot be, right? We cannot give any limitation or condition saying that if you become insolvent, then you are no more the having right over the property. If you dispose of or alienate, if you try, you don't even have to, the person need not even dispose of or alienate the property. If the person puts an effort to alienate the property, then the interest shall cease. No. Why? Because the ownership or the interest or the right shall be absolute upon transfer. Understand? So section 10, 11, 12 have the same logic regarding conditions which have been put forth, which is repugnant to the interest which is created or the right which is created. Okay? Then we go on to the next one, section 13. Section 13, transfer for benefit of unborn person. So what does the section say? Where on a transfer of property an interest therein is created for the benefit of the unborn person who at the time of transfer is yet to be born, okay, subject to a prior interest created by the same transfer, the interest created for the benefit of such person shall not take effect unless it extends to the whole of the remaining interest of the transferor in the property. So what is given here? Unborn person, where an interest is created. Okay, who is not in existence. So it is unborn person. An interest is created for the benefit of the unborn person, then a prior interest which is created. What will happen to the prior interest? Prior interest created by the same transfer, the interest created for the benefit shall not take effect unless it extends to the whole of the remaining interest of the transferor in the property. Okay. See, if there is a, for example, we will take partition, okay, that's the best example. An interest is created on behalf of A. Interest is created on behalf of B. Say, for example, these two are siblings. Okay. So, if an interest is created on behalf of B who is yet unborn, he is unborn. Okay. So, in that case, what happens? There is a prior interest on behalf of A and then there is an interest which is created on behalf of B. So, when shall this take effect? This shall take effect only when he is born. He or she is born. Am I right? But when this interest takes effect, it shall not affect the prior interest which has been already given to the other party. In order to say this, how you will put it? Partition deed, when we give it to A and B, the partition deed shall affect both A and B. Am I right? So the interest of the interest which is created, the prior interest as well as the interest which is created after the birth of the baby is to the entire property. Understand? The interest belongs to the entire interest. It is not restricted to Okay, now because he is living at this time, he gets a prior interest. But this person from the date of birth only he gets. Just because he is born and he gets, it doesn't mean that his share will be affected. His interest will be affected. No. It extends to the interest extends to the whole of the property. So there is no change as such in the interest except that of the unborn person. So when does the transfer take effect? It takes effect upon the birth of the unborn person. Prior interest is what? Just a recap of it. Prior interest is for A. Why? Because he is already existing in this world. Interest is created for the benefit of B, who is unborn. Once he takes birth, the interest shall be for the whole of the property. Understand? In relation to the whole interest, the share will take place. Okay? Then, section 14, rule against perpetuity. Rule against perpetuity. Okay? Now, rule against what do you mean by perpetuity? Continuity. Continuously. Rule against perpetuity means what? Rule against continuity. That means what? A person who is living at a particular point of time, say for example 2017, he cannot say that after my death, the person who is a minor now will attain major, will become a major and hence shall enjoy the property. Understand? The minor, there is a person who is living in the year 2017. What does he do? He transfers the property. He transfers the property to whom? To a minor whom he believes will attain the major age upon his expiry. So till he is living, he will have the property. Then automatically it will get transferred to the minor. This shall not be valid in law. Okay? No transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living on the date of transfer and the minority of some person who shall be in existence at the expiration of that period, and to whom, if he attains age, the interest created is to belong. So what? If he attains. Now again you have to go back to the same logic given in section 10, 11, 12. Why? Because if shows a condition. There shows a limitation. Understand? So the logic is the same. There is a condition, there is a limitation against the interest. See, I am a person who is living now. I have a minor daughter or a minor son. Okay, now I should not actually transfer, but I am transferring. Okay, that is where the entire thing comes. I transfer a property. In that I give a condition saying that I am living now, but at the time of my expiry, if my son or daughter who is a minor now attains majority of age, then the property will automatically get transferred. The interest will belong to that person. That means what? After I die, and if the person is still a minor, then he or she cannot have an interest in the property. So that is actually not right. Right? Where there is a transfer of property, automatically the right also get transferred. So I cannot put a condition on the right. I will transfer the property to you, but I give you a condition. Only upon fulfillment of the condition you get the right. Can I do such thing? No. Therefore, it says rule against perpetuity. Again, if he attains, That if acts as a condition or limitation. Okay. See, when we are reading the law, actually it seems a little difficult or a little easy at times. But if we catch hold of the right word, then it becomes easy for analysis. That's it. We go on to the next section, section 15. Transfer to class, some of whom come under section 13 and 14. Transfer to those who come under section 13. What does section 13 say? Unborn person. What does section 14 say? Minors. Right? So, transfer to class, some of whom come under section 13 and 14, if on transfer of property an interest therein is created for the benefit of a class of person who come under section 13 and 14, such interest fails in regard to those persons only and not in regard to the whole class. See here, what does section 13 and 14 say? Where the condition, where there is a condition, conditional transfer is no transfer at all. Am I right? Conditional transfer. I have all the rights to give my property to an unborn person, to a minor person. I have all the rights. Okay? So what I do? I write transfer. I convey the property by way of some deed to an unborn person or to a minor or to everybody, both of them. But then it will be valid in law. But if I am doing a conditional transfer to an unborn person or to a minor, then it shall be void in law. Understand? So what is important here is, if there is a conditional transfer to the unborn person or minor, then as far as see, if there are A, B, C, D, E, F. A, B, C, D, I am just transferring without any conditions. No conditions. But E and F, one is unborn, one is minor. What I do for these two people, I put conditions. Then the transfer of property will take place smoothly for all these four people, but it will not take place for these two people. Why? Because there is a conditional transfer. So these conditions, when I say transfer will not take place, it's not transfer not taking place. What I mean to say is the interest will fail. They will not get the full interest. Understand? Therefore, the conditions which are there will not be valid in law. Here it will be automatically, it will get transferred. Here there will be a problem. Understand? We go on to the next section, section 16. Transfer to take effect on failure of prior interest. We have already done what is prior interest. So here we are seeing the transfer to take effect on failure of prior interest, where by reason of any of the rules contained in section 13 and 14, unborn and minor, an interest created for the benefit of a person or class of persons fails in regard to such person or the whole of them. An interest created in the same transaction and intended to take effect after or upon failure of such prior interest also fails. So what is there? There is a prior interest which is there. Again you go back to the rules against perpetuity, right? There is a prior interest which is there, but it affects. Whom does it affect? Section 13 and 14. Because there are conditions. Then what will happen? The transfer will fail, that is the interest created will fail as far as the 13 and 14 class of people, that is all of them together. If there is a transfer which says all of you will get the property only if you do this, then the entire class will fail. Or if it is with regard to only two or more persons, two, say for example two, then the interest will fail as regards these two people. Understand? We go to section 17, direction for accumulation. Direction for accumulation. Where the terms of a transfer of property direct that the income arising from property shall be accumulated either in whole or in part during a period longer than the life of the transferor or period of 18 years from date of transfer. Such direction, same as hereinafter provided, be void to the extent to which the period during which the accumulation is directed exceeds the longer of the aforesaid periods, and at the end of such last mentioned period the property and the income thereof shall be disposed of as if the period during which the accumulation has been directed to be made had elapsed. See, here what we have to see is any direction which says accumulation of income. Income can be anything, either debt or interest or anything like that. Am I right? So where there is an accumulation of income and there is a transfer of this, actionable claims, you remember? Transfer of this, and then the person, the transferor says, it shall take effect after my life or after the expiry of 18 years from date of transfer. Okay? In these two, whichever is the longest period. If he dies before this 18 years, then 18 years will be the longest. If 18 years has elapsed, still he is alive, then this will be the longer one. Right? So, after the lapse of the longest period, the interest created shall be lapsed. The interest created shall lapse. See, no transfer will have both the conditions. Either it will have 18 years or it will have after my life. Am I right? Either one only will be there. So, if the contract is for 18 years, if the transfer is for 18 years, accumulation of income is for 18 years, but still he is alive, then at that time, whichever is the longest period, the interest shall lapse. Or if it is life is gone, if it is life and if he does not die, then the longest period, the interest shall lapse. You understand? So, whichever is the longest. So, how you have to calculate? Upon the accumulation of income, okay. But you have to look at the longest period for the conditional transfer. Understand? If I am outliving the 18 years, then after my life, the interest will lapse. If I die early, but it is given as 18 years, then after 18 years, there will be no right to sue. You understand? So, only when the interest is existing, we get the right to sue. So, if it is given that after life and I die early, but 18 years is yet to lapse. So, what happens? Upon the expiry of 18 years, the interest automatically lapses. If I am writing 18 years there, but I am still alive over here, then the interest will lapse after my life. So, my right to sue automatically lapses because there is no interest. Okay? What does subclause 2 say in this? This section shall not affect any direction for accumulation for the purpose of payment of debts of the transferor or any other person taking any interest under the transferor. See, if I am accumulating something for discharging the burden of debt, discharging the burden of debt, or the provision of portions for children, or remoter issue of transferor. Or the preservation or maintenance of the property transferred. Preservation or maintenance of the property transferred. See, in all the other cases, accumulation of income shall lose the credibility, shall lose the interest upon the expiry of the longest time mentioned in the transfer deed. Understand? Except where the accumulation of income is allowed for discharging the burden of debt of the transferor or anyone claiming under the transferor. Either the transferor or anyone claiming under the transferor. If it is for discharging the burden of debt of the transferor or anyone claiming under the transferor, then the accumulation of income shall not be subject to the condition of the longest period of time. Interest will not lapse. Okay. Second one, where the accumulation of wealth is given for the purpose of accumulation of income is for the purpose of children or remoter issue of the transfer. It need not be immediately their own children, the transferor's children. It can be for the cousins, for the nephews, for the niece. Okay. Then third one is preservation or maintenance of the property transferred. Along with the property transfer, there is an interest which is transferred in the income which has been created. Then also the interest will not lapse upon the expiry of the longest period of time if the accumulation of income is for preservation or maintenance of the property transfer. So these are the three exceptions, okay, where the longest period of time will not affect the lapse of interest. Okay, thank you.